All right, for those of you who don't know me, my name is Mike Deschenes. I am one of the senior deputy DAs over at the courthouse. This training is booked for 3 hours. We do not have close to 3 hours worth of material. I know, formal news. Save your booze for later. But that means, as Tim said, please ask questions. So, you don't need to worry about us going over time. That's what I'm saying. If you've got a question, ask it. Is there laws from our vaunted General Assembly? Sometimes they don't write in ways that normal people or other lawyers can understand. So if something doesn't make sense to you, throw up a hand, just say, hey, and I'll try to remember to read the question back for the record and get moving. Any questions before we start? Cool. All right. So we're going to start with the legislative update. These are the new laws that came through the House and Senate. Cool. This slideshow is put together by our District Attorney's Council. So the actual prosecutor lobbyists who have been trying to get these laws pushed through then put this together. They want you to know that this is copyrighted. Lawyers. All right. So kicking things off, we have a new law regarding first-degree murder, bail, and jury selection. This fixes something that happened when the legislature and voters took away the death penalty in Colorado. So when you took away the death penalty, first-degree murder is no longer a capital offense according to the Supreme Court. There was a lot of litigation back and forth on what that meant, but ultimately what it came down to is we started seeing bail available for people who had committed first-degree murder, where normally decades and decades we would not let those people bail out until after they'd proven that there was not proof evident or presumption great, we call it PPG. So now we, as soon as the ballot measure passes, we will return to a time when if you're accused of first-degree murder, you will be held without bail. DA's office will have to do a PEPG again, which those of you who have worked these cases know is kind of like a preliminary hearing on steroids. It's not the most fun thing in the world, but it keeps these folks in custody. This also, in terms of peremptory challenges for trial, jury selection, lays out what is available to these guys. Basically, again, returning, we got something for our side in terms of keeping these people in custody. The defense got to return to selecting a jury like it's a capital case as well, so they can knock more jurors out of the box. Release of autopsy reports involving minors. So generally, a coroner is required to do a public release of an autopsy. This changes that when it's for a minor to sort of help protect both minor and the victim's family's privacy. Does require a written request and permits disclosure only to certain individuals. That is with the carve out there for the coroner. If somebody makes a written request, has the discretion to release certain information, limited information, within 3 days of the receipt of the request. So that's what you would see in terms of like media requests, things like that. Again, it comes down to the coroner's discretion on that one. Any questions so far? Cool. All right. Aggravated cruelty to law enforcement animals. Those of you who attended these trainings last year, or hopefully just one of them, unless you're a masochist, know that they changed the law for cruelty to law enforcement animals, making it a class 4 felony. And there was a lot of confusion. There were dueling bills at the time. So they have substituted some language in there to broaden it and make sure that everybody knows what we're talking about. So certified police working dog or police working horse. That's just under the class 1 misdemeanor for cruelty to service animals. It does provide immunity to veterinarians and people who are authorized to have control of the animal to basically, if necessary, treat and euthanize the animal as necessary. And then there is an affirmative defense to aggravated cruelty and the misdemeanor cruelty to law enforcement animals, where if the person can convince the court to give the instruction that they interfered and hurt the service dog or service horse, due to a reasonable belief that the dog was being used essentially in an unreasonable use of force by law enforcement that could get them an affirmative defense at trial. So that is something hopefully we won't have to deal with, but it is in the law there. And then you guys are obligated under the law to report if somebody is misusing the animal in an excessive force scenario. I don't think that that's news to anyone. It does require, however, officers to intervene if you see that excessive use of force using a law enforcement animal. Some CDL stuff. So always fun for the state trooper crowd. They are creating a crime to when someone directs somebody else to unlawfully operate a commercial vehicle, so people who should know better than to allow people drive trucks or other vehicles that require CDL and require an employee to do so, either because they don't possess CDL or because they're ineligible due to age, they could be charged with a traffic misdemeanor 1. And then, as we see with a lot of these laws, it requires lawmakers to form another committee and look at more stuff. This is specifically DUI enforcement, careless resulting in death, and no proof of insurance. This is obviously directly related to the political atmosphere nationwide, but this clearly spells out that you cannot put together false slates of electors. The electors selected by the voters of the state of Colorado remain the electors selected by the voters of the state of Colorado, and you can't end around it. This does this by the Act HB 241150 does that by expanding the application of existing crimes on the books. So this is not a new crime. They just make sure that that sort of behavior falls under one or more of these 5 crimes. So that's the conspiring to commit offering a false instrument for recording or forgery. It's a fun one. Offering false instrument for recording, forgery, perjury, or subornation of perjury. The penalty level is maxed out at a $10,000 fine. Firearm dealer requirements and permit. So it's an unclassified felony with a pretty big $250,000 cap on the fine if people are dealing firearms without a state permit. State level requirements go into effect February 1st, 2025. Those include the permit obligations for those FFL who are selling firearms. That part of that will require on-site inspections, reporting requirements, and training for firearm retailers and employees. And sets a 48-hour reporting requirement to a law enforcement agency after discovery of a person who the dealer believes, knows, or should know purchased or attempted to purchase a firearm in violation of the law. This would include like obvious straw purchases, things like that. This one, I think, is the one's going to get the most news, no small part because there's going to be a public information awareness campaign launched statewide, but it will be a Class A infraction for people who are using their phones while they're driving. As part of that, the law is very clear. You must, as part of ticketing for this, must actually observe the people using their phone in a manner that is careless. So I don't know how often you guys see that, but in a marked car, I certainly, in my civilian vehicles, see plenty. So have fun. You guys look confused. Well, hopefully not that, but I know what you mean. Yeah. So the question is that this is not actually a change of statute, because this is observed all the time, and there's the requirement that the device must be used in a manner that's careless. I'll look into that. So obviously you guys don't write a lot of these tickets, so I haven't seen a lot of them. So I'll check that one for follow up and get back with you guys on that. Right.
Is that you have to prove that you what to get it. You see what was dying just on the class and happens. What would it was but
All right. Well, I'll look into that and see what changes we're highlighting with this SB 2467. It does. I don't know if this is a new addition or not. Does allow for them to avoid conviction, basically immunize them if they provide proof of purchase of a hands-free accessory, Bluetooth device or something like that, and then sign an affidavit under penalty of perjury. They have not had a charge previously dismissed due to this exception. So sort of a go take a class and get this ticket dumped ability there. And then if the misbehavior is proximate cause of either serious bodily injury or death, obviously the offense would go up, as it would for careless. Does not apply to CDL licensees, and like I said, the public awareness thing. So I'll look into the specifics there for it and shoot an email back to the group. Any other questions on that? Since I can't answer them very well. Prohibition of the unauthorized use of public safety radio. This is going towards people who are interfering with y'all's radio signals. It is a Class 2 misdemeanor to affiliate with a public safety radio network without authorization from the authorizing authority. So this would be anybody on police EMS bands without authorization could be charged with up to a Class 2 misdemeanor. That does mean that police scanners are still fine. It has to be active interference. You have to be broadcasting for this to apply. And this goes for any public safety entity radio band. The gender bias motivated crimes, we see this a lot for the bias motivated harassment charges under 18.9.111. This adds transgender or apparent transgender identity to the definition of things that can be included in bias motivated crimes. So I think that's pretty clear. We're just broadening it. So instead of the race, religion, ethnicity, mental disability, sexual orientation, now also if people think that somebody has a transgender identity and that provokes them to initiate a crime, that would fall under that bias motivated crime. All right. So there is going to be a slight change because there was a jail oversight committee and a jail oversight commission in charge of developing jail standards. The commission is repealed. The committee is extended for a long time until 2033. In consolidating those, the law just lays out what the jail oversight committee is supposed to be doing, and that's the county jail. Any oversight committee recommendations have to be adopted beginning July 1st, 2026. And then within a year of the oversight committee's report recommendations thereafter. There is a jail standards advisory committee that will advise the oversight committee. That will include 2 sheriffs, 2 county commissioners, a public defender, and a physical or behavioral health professional, and a representative of an inmate advocacy organization. So those are the folks who will be giving advice to the oversight committee to make their recommendations. The Attorney General will conduct compliance assessments of jails in conjunction with the advisory committee. I don't anticipate us having many problems as the jurisdiction of this size complying with that. Don't know what this means for smaller jurisdictions. I don't know if you guys have ever been in the jail in Walden, but it's old-timey. Good old rolled steel bars, 2 cages. If they have 3 people, the spryest one has to sleep on the roof of the jail cells. So there you go. We'll see how our sister jurisdiction handles that. People who are detained in jail on emergency commitment. So this is your M1 hold level type stuff. Each agency that has taken a person into protective custody has to provide an annual report to the Behavioral Health Administration. That's an improved treatment facility like Longview, that's PVH, MCR, or if for whatever reason your emergency commitment hold is at LCJ. It will go into effect already, and you cannot take juveniles. You cannot detain juveniles in jail when they were taken into protective custody. Again, I don't think our jurisdiction has any problems with Platt and I forget the other one. But it's just more reporting requirements. So, remember on boss day to get your lieutenant lots of chocolate. We have a new judicial district down in Douglas County, Douglas, Elbert, and Lincoln. That's we in the DA's office are calling the George Brockler Memorial District, since he was termed out of the 18th and will almost certainly run a strong campaign on the 23rd. This is just funding the victim services there like they did last year with the Judicial, making sure they have money for judges. Now they have crime victim fund and bail funding as well, which is great. This is a great one. We have additional protection for victims of sexual offenses explicitly laid out in this law. For those of you who are in persons or aspiring to persons, the clothing, the hairstyle of a victim cannot be used to insinuate that they in any way would have consented to the sex assault or alleged sex assault. We can still talk about clothing in terms of talking about where DNA was found, the state of the clothes, rips, tears, stains, etc. So this is very much targeted at protecting victims and still allowing us to fully prosecute these crimes. If the defense wants to get into this in some way, they have a burden of proof to do so. They have to prove that there is somehow relevance to this beyond just sliming our victims. And the judge must consider this an unfair invasion of the victim's or witness's privacy. This also removes the presumptive admissibility of a victim's sexual history with the perpetrator. So that before, that was deemed sort of automatically relevant that they'd had a prior sexual relationship or an ongoing sexual relationship. That now requires motions and judicial ruling to allow that sort of testimony in. And if they're going to attack a victim as somebody who's making false reports, that is going to require at least one prior incident of false reporting of unlawful sexual behavior that is demonstrably false or false in fact by a preponderance of the evidence standard. So that's something that our SVU attorneys will hash out and everything like that. But this is very good news for victims of sex crimes, helping them come forward and not feel attacked. Protection orders for victims of crimes. So this is talking about civil temporary protection orders at first here. It used to be, before this law, there had to be a showing of imminent danger I don't know how many times you guys have to deal with that, because you guys will normally have a lot of criminal protection orders in our DV cases and things like that. But we do see the civil protection orders being violated, and sometimes they are somewhat difficult for people to get. This lowers that threshold to a risk or threat of physical harm or threat of psychological or emotional harm. That definitely will make it easier to get. We will see what the fallout is of that. Obviously, we want people to feel protected and safe, and protective orders are part of that toolbox. We'll see if there's some sort of overcorrection here, though, because certainly the threat of psychological or emotional harm could be broadly construed by a magistrate. It does not require proof of a likelihood that the acts will continue in sexual violence cases. So again, good news for our victims there. They don't need to say that this person might come back, and that's a likely story. They have to, if they're afraid of that happening, this is a situation where that psychological or emotional harm of not having this protective layer would be well applied. We do have a relinquishment of firearms in DV cases for temporary protective orders. That was only on permanent protective orders previously. And we'll talk about some DV and gun case law in the case law update in a few minutes. If somebody has a temporary protective order and they are seeking to turn it into this permanent protective order, normally there's a hearing, and the protected party and the restrained party both have to be heard from. Now, with this new law, the permanent protective order can be granted without any additional testimony or evidence from either the petitioner, and grants a default permanent protective order if the respondent fails to appear and was properly served. This is stuff that will be helpful information for victims of crimes if they are seeking. Sometimes these criminal cases aren't as strong as we'd like, and that's where the civil protection order system comes into play to really help victims. So this is good information for you guys on the street. It's also very good information for victim advocates to have, to advise victims clearly of what their rights are and what their protections can be. If a court denies the temporary protection order, normally there would be some sort of service. There's some magistrates felt that because the respondent, the restrained party, was named in this court proceeding, that person should get notice that this protection order was sought, even though it wasn't granted. Obviously, that puts victims or people who feel like they could be victimized in a pretty tough spot. Now they don't have a protection order, and the person that they feel they need protection from knows that they don't have one but wanted one. That's gone now. The courts, if they're denying the temporary protective order, there's no service requirement on the respondent. And cell phone service providers can be ordered now to separate accounts in cases where we've got sex assault, stalking, and domestic violence. Another way to sort of cut away control, even if our perpetrator has their name on the account and the victim is on the family plan, they want to get away. Now there's an explicit law that they can go into AT&T or wherever and have that happen. Crime Victim Compensation Act is getting updated. I don't know if you guys have talked about this or seen any of the press releases about this, but we've been doing really good as a state on crime victim compensation. We're taking good care of folks. I think we ranked 5th in the nation in terms of payout, and we're not the 5th biggest state. Our jurisdiction alone, with Jackson and Larimer counties, provided more victim compensation to the victims of crimes in our community than the entire state of Maine. So, suck it, Maine. Now, motor vehicle theft will be expanded to compensate for losses related to that, including damages. Replacement services loss, new term included in there. This also removes the 72-hour reporting requirement plus an FNE exam as equivalent of evidence of a report. This is just for people who are, again, seeking to get compensated. This makes it easier for them. Also removes the statute of limitations, which was previously 1 year, in filing for compensation. We have more types of aid that we can offer to our victims, including travel to court, travel for services like therapy, dependent care and relocation costs, towing impound costs, and medical prosthetic devices. The medical emergency approvals limit is now subject to board policy, not amounts, because previously been capped at just less than $10,000, my understanding, which the medical bills can add up quite quickly. Don't quote me on that, though. And then CVC fees must be paid to diversion participants. So even people who are not going through the court system, or rather dealing with their case just with law enforcement or prosecutor agencies, they are still going to have to pay into the CVC fund and keep that well funded moving forward. Peace officer and post, that's you guys. You can now get provisional certification if you have previously served as a law enforcement officer in the military. So help us recruit some MPs, make it easier for them to convert into civilian law enforcement. Law enforcement agencies now need to establish policies, if they don't have them already, surrounding the use of prone restraint and recovery of individuals who are in the prone restraint. It does not regulate when you use it. Just saying there needs to be a policy that everybody has access to in the department. These agencies, all agencies must draft and implement these by July 1st, 2025. The policies must be published. Everybody must be trained on the policies, and review of the prone restraint policy has to occur at least once every 5 years. Post will have to make this training available to all law enforcement across the state. CBI investigators are now have statutory authority to investigate any activity involving firearms. They have to communicate. They have to go through deconfliction. They have to work with you guys in order before they file charges or make an arrest or anything like that. If there are other criminal activities attendant in their firearm investigation, they have to work with you guys. They cannot come in and big time you guys and take cases away or file charges unrelated to their firearm investigation. And as part of that, they have to comply with body cam requirements. So, child safety seating. It used to be from under 8 years of age. Kids had to be in some sort of safe seat. They're moving up to 9 years of age. It also changes the age and weight limits for children to be properly restrained in either a rear-facing or front-facing car seat. In the rear seat of the vehicle, obviously, if they have them, that goes into effect January 5th. I don't know how much you guys want to get into the weeds on that one, but it basically more tracks with what the manufacturers recommend of these seats. I don't know how many of you guys have kids. I have a 6-month-old. She sits now in an astronaut seat, and it comes with 16 layers of instructions on when to do this. I compared them to the statute, and that's what tracks. So they're asking people to be a little more cognizant, I guess, of current and modern child safety seat recommendations. Basically, under 40 pounds, under the age of 2, better be in the rear-facing position. If they're under the age of 2 but over 40 pounds, they could be transitioned to a forward-facing system again. So if you guys have any specific questions about that, I've got the whole statute here, but I'll just move on otherwise. Cool? You can't park or block access to loading zones, ramps, access aisles, anything like that that are clearly identified as there for ADA accessibility. You can be fined if you do so. If you as peace officers receive complaints of people parking in ways that obstruct access for people with disabilities, you must investigate within a reasonable time. There you go. I'm sure that, yes.
If the give up private properties, well, like is in art.
Let me scan the statute here real quick. But the question was, would this apply to private property? My understanding is because this is a monetary fine, that yes, this would apply to anybody who is cutting off ADA access. So if it's clearly marked as this is where the van parks and there's area blocked off for the lift to get down for the disability van, and somebody parks their carpet cleaning truck there to make a run in for groceries, and somebody complains, you guys can roll out and you've got this ability to find them now. Motorcycle lane filtering and passing. So it's not lane splitting, it's lane filtering. The rule is they have to be passing cars that are stopped. They have to be going 15 miles an hour or less. When cars start moving, they have to stop doing it and get merged back into traffic safely. So they cannot do it on the shoulder. They cannot do it on what would be the shoulder if the road didn't have a shoulder. And let's see if I'm missing anything. The conditions must permit the prudent operation of the motorcycle while overtaking or passing. So sort of the careless driving language there. Right.
We start getting those violations to what was breaking that. I mean, why did she do better than he has done?
So the question is, would these be better ticketed as lane violations or careless driving? And honestly, the answer is going to be the one that you hear from lawyers all the time. It depends. So if somebody's doing 20 and not merging back in well after traffic starts moving, that sounds like a lane violation to me. If somebody's doing 65 and even though the cars are all stopped, that sounds like they're about ready to. They're lucky they're not going to get a rear view mirror or side view mirror. So that sounds a lot more like careless to me. But y'all are the experts, and it comes down to your judgment. So if you see something and it seems like this person is not behaving in a prudent manner given all the conditions, you've got options. Commercial vehicle highway safety measures. This does not apply to us at all. But basically, there are safety zones where big trucks cannot be in the left-hand lane, except in certain exigent circumstances. This expands them. It makes more of them. I-70 is still going to be a nightmare. So there you go. Immigration identification document issuance. So these are for folks who are in the U.S. illegally. They have been able to get a driver's license for some time. This just makes it somewhat easier. They need certain identifying documents such as a passport or other specified documents as laid out in the statute. Previously they had to provide proof of tax returns, affidavits of proof of continuous residency, taxpayer identification number, or issuance of a social security number. So this will allow hopefully more people to be legally licensed, which we know means they're more likely to be insured, which it makes everybody's lives easier. Hopefully. So, protecting vulnerable road users. This is a CDOT and State Patrol focused law that also affects y'all in that we can put up these automatic vehicle identification systems for the purpose of detecting traffic violations on any portion of a state highway, according to this. There are other places that you can put these cameras as well, going through the statute in terms of construction zones, even though they're not on highways, places near school zones, basically any place where you have increased danger to the community, be they flaggers, be they elementary school students, you can put up an ABIS system there with the coordination and approval with CDOT and CSP. The CDOT will be putting out rules at the end of, well, at the very beginning of next year. It cannot apply to toll roads, and if you are violating, if you get a video ticket in a rental car, the rental agency has to go after you. It's not law enforcement's job to track down who the actual driver was. The rental car company will be liable.
Just to clarify, so that would be like a speed detector at 5 miles an hour instructing zone. Would that be about this? Is it?
Yeah, so the question is, in a construction zone on the highway, we could put up a speed monitor and issue digital tickets from that. That's absolutely correct. There is the requirement. I don't know if it's not on the slide. There is a requirement that there be clear signage, and CSP and CDOT. Oh, it's on there? Okay, cool. Skipped ahead. There has to be signage within 300 feet of the ABIS system to let drivers know. So it's really just trying to take advantage of people who can't read. Let's see. Supports for the youth in the juvenile justice system. So this is for those hopefully rare encounters where we're detaining and arresting juveniles. The court must take into account the juvenile's educational progress and ability to achieve credits towards graduation. Now, I know at Platt, there's plenty of classes there. Lots of our juveniles find the stability and regimentation of their schedule in detention to be very beneficial to their academic career, but this just requires the court to, when detaining the juvenile and considering bond, seeing if it's going to mess with their school life. This goes for committing to Department of Youth or DYS for an offense that does not include physical threat or bodily injury. If they're being committed, I guess this just goes towards length of sentence, because if they're already being committed, that's, I guess, how you weigh that. And then if juveniles are being put through a diversion program, probation, or being questioned about a crime, they have a right to privacy at school. Basically means shouldn't be perp walking kids to the principal's office or interrogating them around their peers, things like that. Ask your SRO. Reducing the harm of substance use disorders. So this one expands the immunity for administration, essentially, of Narcan. It's the statute keeps it vague so that other life-saving overdose cures could be included in that. So, but as we get more and more of these synthetic opioids like Natazine, things like that, we're probably going to see more Narcan level interventions, or as they put it, opioid antagonists. The presence of Narcan, either a used Narcan canister or just carrying Narcan around, can no longer be used to establish PC that this person has or could have opiates on them. And then similar to that, if they are part of a needle exchange or some other paraphernalia providing opioid treatment program, or harm reduction organization, that is also not something that can be used to write for paraphernalia.
Is that thing something this?
No, they kept it pretty vague. So it would be anything that they're getting as part of a participation in a harm reduction program. So
These are units meant like stick with and all the white things for this, the daddies, but they have to put in the card. Is that correct?
that is correct.
So like, we all know where that stuff comes.
Right.
It's just that they have it, and all, let's sue that they're getting it, and they have.
Yeah, so the question is whether or not they have to present the card in order for this to work. Yes. Now, on the back end of things, if you guys ticket them for the paraphernalia and then they come in and produce a valid card that they didn't present to you guys for whatever reason, the likelihood of that paraphernalia charge sticking is pretty low in terms of how the DA's office will be handling that. But if that is, they can't go back and say, hey, I had this card on me the whole time. I shouldn't have been ticketed for this paraphernalia, which then led you guys to find, 40 blues in their pocket. They're still going to eat the charge for those blues, as far as I'm concerned. No. Yeah.
It's about By the way,
So the question is, in interacting with the community and seeing people actively, like with this paraphernalia, especially in use, what options are left? There's still the unauthorized use. You still have your DM2s, things like that. I would say it's something that we could cabin up together, especially with the city, where we're talking about Old Town, and try to come up with how those cases are going to be handled. But the legislature has deemed that those folks who are using harm reduction organization provided materials cannot be cited for possession of those materials. Now, possession of the illicit substances, if they've got more than, empty baggies and cold pipes, that's still in play. Unauthorized use is still in play.
it's going to be up to them to prove what they got on this place. They're giving out full smoke. It doesn't matter if they sold what oil from Bargafino or if they got what did you that that band's about.
Yeah. So the question was, paraphernalia comes both from these organizations and can be produced outside the organization. Yeah. And I would say on something like foil, right, where we're not going to be able to distinguish whether this is something that they made themselves or something they received from one of these harm reduction organizations, you're going to be out of luck on that one. Now, something like an improvised pipe, I think, again, you guys are going to be entrusted with using your judgment on that. Like if they're smoking meth through an apple, I don't think anybody gave them that apple in a safe space, or a light bulb or something like that.
I've got a bowl. Well, you want like a tour, like they can be even up that a bit for the park. Now he more than the straw that in the definitely about it.
Yeah. So
and then the next part of that would be with drug fair only with some NC to get to the vehicle. Drug fair on one is that gonna affect the beats? The certain vehicle and DC but
So, two questions then. You're good. One is pointing out somewhat of the absurdity here of somebody could have an NCAP card, be issued a sterile tutor or whatever, make their own out of a pen. One is okay. one isn't. And that's absolutely, that's my understanding of the statute. This is designed to encourage people to be going towards places where they can be engaging with treatment to some level. So if they are ignoring that, even if they have an NCAP card, but this is not something that any medical or safe or harm reduction organization is actually going to be giving somebody, that's still going to be eligible for a paraphernalia charge. Building off that, the other question was, if you see obvious paraphernalia in plain view in a vehicle, will that still provide PC for a vehicle search? Yes. We will fight this out. The defense bar will, I think, take an opposite position, but I think it's clear that drug use is still prohibited under the law. Illicit drug use is still prohibited under the law. And if there is paraphernalia of drug use, that can still establish a reasonable belief that further evidence of drugs or drug use will be found in that vehicle. I would have no problem fighting that in motions, and I don't think anybody in my office would either.
It's not even go because what we're saying, like what we're saying now, both based on this, if they have like what we could identify is that period, and that's what we're seeing in the car. Let's say that is no long PC, like it's speaking no long in sight session. Correct or no?
Okay, so the question is, and I'll build off this in my answer. Obvious NCAP material, obviously not eligible to be charged as a paraphernalia drug petty offense. Will that still provide PC even though it is not chargeable? And my answer is, as far as I'm concerned, yes. And the reason is PC is not contingent upon a chargeable offense, right? So if you're looking in a vehicle and you see evidence that somebody has been using drugs, that you guys are reasonable officers, you're there to protect the community and enforce the law, and you can develop that probable cause even though you're not starting with a chargeable offense. Cool? All right. Now wait till next year when the legislature changes that again, but for now, okay.
It's anybody you do this in the car, someone don't eat one.
Correct.
May or may not. At least the thought, yeah. You don't push the it makes this and anything to that.
And that's a great example. Yeah, I'm going to steal that. So, empty beer cans in the car.
That's not wordy, but dead.
All right. We'll work out a fee schedule. Okay. Sodium nitrate. This is one of those laws that came about because of one bad situation. Bruce Brown, who's a former elected DA in the 5th Judicial, so that's Breckenridge, Vail, Eagle. His 17-year-old son was kind of coached into committing suicide using sodium nitrate, which is normally used for curing meats, but it's basically a heavy enough dose of sodium when taken incorrectly that it is most assuredly lethal. So former DA Brown really championed this and pushed this through the legislature. That, since it's a bespoke law, I don't know how much we're going to see of this, but it basically makes it so unless you have a valid commercial use for sodium nitrate, it cannot be imported in large quantities to a person in our state or transferred among people in the state. It also has labeling requirements and record retention, basically declaring this is a dangerous material. It's because in high enough doses, again, very poisonous. Violations are civil penalties, $10,000 for the first violation and max $1 million for second and subsequent. I don't know how much this will apply. You do see this came from interactions online. So you never know when something like that is going to take off and be a big deal or just be a blip on the radar. But we now have the ability to enforce regulations against the transfer of a dangerous substance that causes death. Okay, SB 2447, Prevention of Substance Use Disorders. This permits county and districts to form multidisciplinary and multi-agency drug overdose fatality review teams, which can request and receive information from certain agencies, including DA's offices and law enforcement agencies. I don't know how many of you guys work much with Dan Bonds. He's really pushing forward a lot of the fentanyl overdose awareness and works a lot with national organizations. This is going to be a more local level focused on overdose death things. I don't know if our county or district will be pursuing this, but this allows them to do so and allows them to get records from, like I said, law enforcement agencies to help formulate advice, I imagine, or advisory campaigns, anything like that. A lot of stuff that I think, again, in our jurisdiction, we already do very well. The records that they get are not eligible to be picked at through Open Records Act requests, and anything law enforcement gets from this team cannot be used. So they have the ability to keep law enforcement stuff private, and then anything they get from people who are engaged in the drug community would likewise be protected. So they can hopefully get good, accurate information and provide us excellent advice moving forward. Guns. So concealed carry permits are now going to have very clear guidelines and standards. There needs to be any concealed permit that issues after July 1st, 2025 they have to be taught by certified instructors. The sheriff will be responsible for certifying those instructors. Has to be at least an 8-hour class. Has to include live fire and written exam requirements. So people have to pass all that. And then if you are getting a refresher course to re-up your concealed carry license, that is a 2-hour refresher course that will also require written exam and live fire exercise. And the sheriff will be responsible for figuring out making sure that certified instructors follow all of the requirements under the statute. People are now required, as of January 1st, 2025, will be required to lock up their firearms in a vehicle. Handguns have to be locked in a hard case. Non-handgun firearms can be in a soft case so long as there's a locking mechanism on, like a trigger lock or action lock on the weapon. They need to be stored out of sight. A glove box technically counts as a hard case, so locking a handgun in a glove box counts. There's exceptions for law enforcement, active duty military personnel, ranchers, people like that, so they can still have the shotgun rack in the back of the pickup. But overall, citizens in the city cannot just have their handgun laying on the seat, things like that. I know those of you who've worked a lot of juvie cases, that's I was in juvie for 2 years. That's a constant frustration. How many unlocked cars have unlocked guns in them? This creates a little bit of incentive to try to drive people away from doing that. Prohibiting carrying firearms in sensitive spaces. So there's already a bunch of laws. This expands them. There's already a bunch of categories under this law. So you couldn't carry guns in like child care facilities, things like this. This is to changes 2 things really. One, it includes concealed with open carry. So if you are not supposed to carry a gun in a courthouse, doesn't matter if you have a CCW or you're open carrying, you cannot do that. This also includes a lot of government, basically anywhere there's elected official offices. So there's government offices and courthouses where there's concern about people showing up armed by the people who made this bill. They did a good job. They did a good job narrowly tailoring the law to make sure that if they are giving a speech, nobody should be armed, or they could face a Class 1 misdemeanor. This, of course, is there are exceptions throughout the law for anyone who is carrying a firearm as part of their lawful duty. So law enforcement, active duty military personnel, things like that still are able to do that. If people have, this does include the adjacent parking areas, but if somebody has a CCW and they are storing their firearm, handgun, in accordance with the prior slide in a locked hard case, that's fine. But if they have their gun out to do anything besides put it into store, take it from holster to storage, there's gonna be a problem under this law. It reduces unlawfully carrying a weapon on school grounds from an F5 to an F1. So it is M1 across the board. And like I said, includes all firearms, whether openly carried or concealed.
Making that off.
Correct. So the question was, responding to the slide, the dangerous weapon category of gun has been dropped to an M1 to remain consistent with other locations. Because why should we have special rules for schools, guns? But dangerous weapons like knives are still going to be the F5. Your General Assembly, ladies and gentlemen. Elections. So if you are currently, your hobby is making deep fake videos of prominent politicians, this law applies to you. Don't do that. You will be held criminally liable for making deep fake videos. This includes videos that, and do you guys know what I mean by deep fake? Okay. That's where you use, take somebody's picture and use an AI program, which are readily available all over the internet. And you take that person's face or voice and you map it onto something that they didn't say or do. So classically, they do that in movies, to have, a former president in a period film deliver a speech that they never delivered, right? But in the context of how this is being used for the last couple of years, it's more about making people say things that are outrageously untrue and do not reflect their policy positions and may be in many ways offensive. So they kept it pretty vague, but I mean, you don't have to use your imagination to figure out what people would do in terms of politicians they disagree with and being able to portray them doing pretty much anything. So anybody who's been victimized by this, any candidate, again, this is related to election stuff. Hopefully we'll see something that applies to those of us who are not standing for election. But there you go. Right now, does provide candidates the ability to bring civil actions or injunctions against the people who created it or the people who are knowingly distributing it. And does not exempt people from liability if they knew that they were distributing something that was not true and portrayed somebody in an unfavorable light. That does include, recklessly distributing as well. So knew or should have known. A little bit of critical thinking keeps you from being liable for suit by aggrieved politicians, which doesn't sound fun. So, privacy protections on criminal justice records. The current law, we have to completely redact anything that we send out for an open records request that for sex assault victims. This also includes juveniles have to be completely redacted out, whether they are witnesses, victims, or juvenile defendants. Now, because that law was a little overbroad and people were like, well, this is actually getting in the way of doing our jobs in the criminal justice system, there can be unredacted records involving child victims and witnesses to the Public Defender's Office, ADC, that's the Public Defender Conflict Council, the children's parents, or respondents' parents council, so that's the the folks you would see listed on the case caption in a juvenile case, and then municipal county attorneys and the named child's legal representative. Okay. And that's retroactively applied, so it's already in place back to January 1st. Nobody's allowed to die from excited delirium anymore. And people are not supposed to use that term in reference to any sort of medical condition. They're not even supposed to train on it except as historical, like, look how bad we used to do things that we don't do anymore sort of job. So I've never seen excited delirium in a police report in this jurisdiction. I've been here for a while. I don't know if y'all are upset about that, but I don't think it really affects us. And then it is going to be easier for people to seal and expunge prior charges, not changes. This makes it easier in cases where there was the wrong person was arrested or was charged incorrectly. Deferred judgments, acquittals, and dismissals that have occurred. This includes VR victim rights cases, which generally does slow things down quite a bit on any sort of process. So this is making it easier. If previous illegal conduct is now legal, so possession of psilocybin, marijuana, great examples of criminal convictions that are no longer going to be charged. So those folks have a much easier path to sealing their convictions, and makes it easier for access to sealed records by the people or their attorney, in terms of so they can get legal advice based on that. So that's really a trial lawyer concern. And folks are allowed to participate remotely in motion to seal proceedings. They don't have to be there in person, or it's not presumptive that they should be there in person, reflecting our more digital age. And if a case was dismissed due to incompetency, previously that could not be sealed. Some of us really liked having access to the litany of charges that folks who are incompetent have accrued. Now those will be eligible for sealing under the statute. So they'll still have to meet all those legal standards and rigors that they were incompetent to understand before. Sure. So this online facility of misconduct and remote tracking mostly refers to dating sites. Basically, the legislature has decided there needs to be more regulation of what people are doing on Tinder. And that really comes down to reporting requirements. If people are not verifying that folks on their site are who they say they are or are over 18, that needs to be part of their disclosures associated with the site. So, and then it does expand the crimes of people of what we would call revenge porn, the posting private image for harassment or for pecuniary gain. So that change is kind of related to the deepfake stuff. So if you've got a picture that was somewhat scandalous and you decide to make it truly spicy with a little AI enhancement, that's still going to count under the statute. You can't be like, no, she didn't actually show that much. I just cut and pasted with, from another source. That's still going to be, because the victim would still be affected by that, that's no longer going to be any sort of defense under the law. Human trafficking laws, or cases against human traffickers are being strengthened by SB 2435. So the big thing there is people who are being trafficked, if there's involvement of SBI or weapon in that trafficking, now that will count as a COV in terms of our side of things. DOC, different story. I can't speak for them. Statute of limitations for people who are bringing a complaint of being a victim of human trafficking has been extended from a decade to now 2 decades. Statute of limitations for child human trafficking remains unlimited. And then if there is an affirmative defense now for people who themselves were victims of human trafficking, so what we see sort of with the massage parlor sort of game, where the people who are running this show are also being trafficked themselves and trying to earn their way out, that's they will now have an affirmative defense. Even though they're running other people and perpetuating the system, they can now in court say, you shouldn't convict me because I have no control over my situation either. That again will be something for the lawyers to fight over, but something to bear in mind. Youth sports organizations are going to have to teach their coaches to be better mandatory reporters and better behaved. So they need to complete an annual abuse prevention training. That includes those bullet points. So what coaches can and can't do, how to have one-on-one interactions that are safe for the players and coaches. Again, those mandatory reporting requirements of a coach, how to recognize and appropriately respond and prevent behaviors that violate the conduct policies of the sports organization, and how to respond to disclosures of sexual abuse, child abuse, or reports of behaviors violating the conduct policy. So that's good. This does not apply to neighborhood youth organizations, public and private schools, kindergarten through 12, licensed child care facilities, and institutions of higher education. So that's a pretty narrow group of folks who are now going to be trained up annually on their mandatory reporter requirements. And every youth sports organization is required to put together their policies. All right, there's our contact card. Any questions at the end of the new laws? All right, easy enough. Let's go to the new interpretations of law. Once I figure out where my mouse is, there we go. Cool. All right. We've got a bunch of cases from the United States Supreme Court that affect us. First is Rahimi. This is a case where this guy got, as part of his bond, told, you've been accused of domestic violence. You should not have a firearm. Do you understand this? Do you contest this? He didn't show up to the contested hearing. So the court said, you may not possess or control firearms, similar to our bond requirements here. The victim did testify to present her side of the story and talk about how threatened they were. So overall, good order. Shocking nobody. Rahimi continues to possess a firearm. He then gets caught doing a second firearm-related domestic violence incident with a different victim, and gets this federal charge for basically violating the protective order and possessing a firearm when the courts told him not to. He then challenges that under the Supreme Court's holding in Bruin, which said, there has to be, any gun regulation has to be seated in historical precedent. You have to be able to point back to much older laws saying that when the Second Amendment was being understood and ratified, these sort of regulations were in place and were reasonable. This is Texas. It goes up to the Fifth Circuit. Fifth Circuit says, hey man, we don't see anything saying threatening your wife with a gun or girlfriend with a gun means you can't have a gun, so dude can have his gun. When he was arrested, by the way, he was implicated in 5 other shootings when they arrested him. So not only did he have this menacing that they picked him up on, but he had 5 other firearm-related incidents, one of which was his friend's credit card got declined at a burger joint, and the dude pulled out his gun and popped off rounds. Very upset. He had to pay for dinner, I guess. But anyway, easy to see. This is not somebody that anybody in the community wants toting around a gun with impunity. But Bruin is going to be creating these ripples through our jobs for the next, I don't know how long, where every restriction on gun rights is going to face these sort of challenges. No, in this case, the Supreme Court did say, no, hold on. We can find plenty of evidence that people who are inherently dangerous with a firearm and have demonstrated that and have had a hearing to contest it can have their firearm rights, their Second Amendment rights, temporarily restricted, even though they haven't been convicted of these crimes. So based on that, they said, oh, you guys have totally misunderstood how to apply Bruin, which again, we're going to be hearing that a lot for the next 30, 40 years. They said because this was a credible threat to the safety of another, and because all these safeguards were in place for due process, there is no problem with temporarily restraining people's Second Amendment rights. So this is one, we're keeping the slide in here just because it deals with expert testimony. And when you guys are seeing trials get kicked down the road a lot, this might be part of the symptoms. This is a case, Smith v. Arizona, where drug case, drugs got analyzed like they would at CBI. The analyst who did the actual testing and put together the bench notes and lit packet quit a few weeks before trial. So the DA said, that's fine. We have other analysts who can come in and read these notes. So that's what they did. They came in and said, according to these notes, the analyst who did these tests did everything right. They used the laboratory blanks to make sure there was no contamination. All their measurements link up with what we would expect based on the evidence. Chain of custody is great. Everything's good. Supreme Court said, no, you didn't do the testing. You can't talk about what the testing showed. That implicates Crawford and the Confrontation Clause. So we need the actual expert who did the testing to be there at trial. So that will, we see in our jurisdiction in Colorado, that is, the encroachment of expertise into trial where, you guys 12, 15 years ago did not need to be experts in HGN to testify about HGN. Now you need to be experts in HGN. 5, 6 years ago, you didn't need to be experts in using a canine in order to testify on dog alerts. Now you need to be an expert in canine to testify about dog alerts. So I don't know how this will affect things long term. My inclination is in terms of your guys' direct job and your direct expertise, it won't. But when it comes to blood results, chemical tests of drugs, DNA testing, we're going to see further delays of trial as CBI tries to manage both the workload that they're naturally getting overwhelmed with and then the workload of anybody who quits, leaving behind just everything will need to be retested if it's going to be admissible. So, fun times. Okay, Chiaverini. This is one that I know everybody's careful. I know everybody does their job well. And in this jurisdiction, we have an additional safeguard of almost anything that you guys are filing is going through the DA's office. So everything's being evaluated like 3 times before a charge hits. But here's what happened in this case. Chiaverini was picked up. He had stolen property on him. He had this $45 stolen ring. He gets charged with that, with the stolen property, with these low-level misdemeanor offenses, as well as money laundering, which is a statute that can, sort of like art, it can apply to a lot of things. The court found that the charges were not presented to a grand jury in a timely manner. Again, we don't use a grand jury for most things in this jurisdiction, so it doesn't apply. So those counts got dismissed. Chiavarini then, of course, turned around and sued all the officers in the police department under a 1983 action. And the Supreme Court found that because that money laundering charge was there was no PC for it in the affidavit or presented to the court, so the record was sterile as to what supported that money laundering charge, he could sue the police department and the individual officers. And the government tried to argue, hey, this guy did have legit charges, these misdemeanor charges. We know like he's not a good actor. And the Supreme Court said it doesn't matter. Any charge that's not supported by PC can be a civil rights violation. So again, we are very careful in this jurisdiction, both on your guys' end in the investigation and recommendation of charges, and then on the DA's end in reviewing the charges. So I don't see this being a problem, but this just underlines the fact that we need to be careful and make sure that every charge that we levy against people, especially felony charges, is justified. Okay. This one, a little bit better for us. This is Diaz v. United States. Diaz was a drug mule. She had 54 pounds of methamphetamine with a street value of somewhere around $380,000 stashed in her car. She gets picked up at the border and, to everyone's surprise, had no idea that she had 54 pounds of methamphetamine in her car. Not her pants, guys. She takes this case to trial. At trial, the prosecution, in this case the U.S. attorney, it brings in a Homeland Security expert to say, yeah, in general, these mules know what they're carrying. And she says, hey, you can't testify as to what I knew or didn't know. Now, an important distinction is that is true federally. It is not true in Colorado. In Colorado, we have that particular rule of evidence is not in our Colorado rules of evidence. So when they talk about federal rule of evidence 704B, we have Colorado rule of evidence 704A, no B. So doesn't necessarily apply, but it's still a good stricture in terms of Supreme Court said, that's fine. What he testified to is fine because he wasn't testifying as to her particular mental state. He just said, in general, in my 15 years of law enforcement training and experience, these mules know that the 54-pound bag in their back contains drugs. They're dealing with the cartel. The cartel doesn't pay you good money to run nail polish across the border. Fair enough. Jury went with that. Now, under the federal rules, if he said, no, she absolutely had to have known what that was, this particular defendant had to have known what that was, they would have been in trouble. We don't have that worry here. But this is a case that we want to highlight for y'all in terms of this is why preparation for testimony is important, because that's a fine line for their expert to have walked. He did, got the conviction was upheld, all good, but this is why preparation for testimony is really important, because it is just becoming more and more of a minefield with what can and cannot be said at motions hearings, preliminary hearings, and trial. Our office should be reaching out to you to set up meetings prior to your testimony. You guys should not be surprised by any of the questions we're asking. If we are not, please let us know. If you are worried about being called in to testify and you haven't heard from your DA and it's this week, sometimes it's because we're prepping and we're going to get you guys a complete set of material and go over things with you. But please don't be shy about reaching out either directly to the DA or to a supervisor at the DA's office, because we want to make sure that our cases stick. You guys put in a lot of work on the investigation side of things. We don't want to screw things up because we didn't prep you well for what the defense was going to ask or what we were going to ask. Because that's what would have happened badly in that case, is the prosecution would have asked a question too vaguely and gotten too specific of an answer and then have to retry this case, which, I mean, those U.S. attorneys guys, they carry like 20 cases at a time. This would be get 21. It's a lot of work. So that's just I'll get off the soapbox here, and move on to Garland v. Cargill. This is the bump stock case. So what happened is after the Vegas shooting, where that guy was up in the MGM, I think, with the bump stock and just laying down insane amounts of fire into the country music festival, the ATF said, oh man, bump stocks turn these rifles into machine guns. Therefore, we should be regulating those and prohibiting people from having bump stocks just like we would machine guns. Supreme Court says, no, you guys can't make those decisions. You guys in ATF can't make that decision. You have to be specifically told by Congress that this will fall into that category. Really, the harm there was the difficulty the Supreme Court had there in their rendering of this opinion was that the ATF had not qualified them as machine gun before the shooting, and then after the shooting they did. So they're not allowed to change their mind after seeing a pretty horrific application. Has to come through Congress and then go through the courts. So they exceeded their statutory authority. That means in terms of at the federal level, bump stocks are legal to own again. Now states can restrict those through congressional action, but we cannot see federal charges at this point for bump stocks. All right. City of Grants Pass versus Johnson. This is what we're seeing all the news out in California right now. Basically, the Supreme Court said it is perfectly legal for cities and counties to say you cannot camp. Homeless people cannot make these huge encampments just because the shelters are full. That was sort of the ACLU and other homeless advocacy or unhoused advocacy groups' argument was, hey man, like you can't even say you could go to a shelter's full, so public property should be in play, sidewalks, public parks, things like that for homeless encampments. Supreme Court says no, these are public places for the enjoyment of the public, not for the assumption of like you just can't go and say, nobody's using the sidewalk, so I'm gonna do my thing on it because I'm a member of the public. So that's why we're seeing a lot of, like I said, out in California, these homeless encampments getting rolled up in public places. I don't know how many of you guys remember Jefferson Park. We used to have a park where Union is now. And because in no small part, no, actually directly related to the homeless encampments that kept cropping up there, the railroad said, cool, we're going to sell that property and we're going to put an easement on it that says it can be used for any purpose except a public park or homeless services. That was actually one of my first cases as a new DA was when those started getting written from Muni court into county court. So I got to see William Montgomery in trial, and he still remembers my name. So there we go. They said because it's they brought it under Eighth Amendment theory, saying it's cruel and unusual to say you can't camp in the parks when the shelters are full. Supreme Court says no, nobody's being punished by a legal entity. We're just saying there's certain reasonable prohibitions over the use of public areas. pretty reasonable. We'll see how it plays out. These are the Colorado cases of interest. I don't know if you guys recall last year's presentation. We had this case from the Court of Appeals. It's Dine v. People. This is where they had a search warrant. They went to the house and then found out that the house had been, without any sort of property record detailing this, turned into an up-down duplex, but they shared an IP address, so they continued to execute the warrant. And the guy in the basement apartment that they did not know exist turned out to have child exploitive material, which is what they were there to investigate. And he says, hey, man, you didn't lay out in the search warrant my separate apartment. And so you didn't describe the area to be searched with enough particularity for your warrant to stand. The Court of Appeals said, no, man, it's fine. And now our Supreme Court said, no, man, it's fine. That warrant is good. The lesson, though, is when you guys are drafting your search warrant affidavits, be exhaustive, because the trial court said it was due to inevitable discovery that the warrant was good. The Colorado Court of Appeals said, no, the warrant itself sufficiently described the area. And then the Colorado Supreme Court operated under a different theory, saying, no, because of the public record search and everything like that, there was enough due diligence there that even a deficient warrant was good on all four corners. So 3 courts, 3 different interpretations of how that warrant was good. If that warrant had lacked one of the things that these justices or judges latched onto, who knows what would have happened. So just a little lesson there in terms of when you're dealing with lawyers, you don't know what they're going to find gets you there. Yeah. Right. So that's the an exhaustive list of all the stuff I just talked about. So people in interest of JG, this is for the SROs and friends of SROs out there. JG, juvenile, for whatever reason, probably somewhat troubled child, gets put on a safety plan that says his backpack needs to be searched every day for a gun. So he goes through 9th grade, freshman year, every day getting his backpack searched for a gun. He's all in compliance. He starts his sophomore year. First few days, they don't search his backpack, and then they're like, oh, hey, right, JG, we got to search your bag. So 3rd day of school, they search his bag. There's a gun in there. And he says, whoa. Like, that was last year's plan. So said that the search was bad. Let's see if we... So, judge, what's that?
Said, no.
Right, yeah. Now he's only a misto. Right. The judge denied their motion to suppress, saying that the safety plan was still in effect. Relevant information there. These school safety plans don't come with expiration dates usually, and this one did not. Also, integrated education plans, your IEPs, same deal. They tend to carry over year to year and only be reassessed on a as-needs basis. So everything stayed kosher. The search was good. This gun stayed in, and that was upheld by our Supreme Court as well. So there you go. People v. Johnson. Deputy observes an illegal U-turn, reports that to somebody who's in the area as well, the sergeant, who also observes a second illegal U-turn, pulls over the vehicle. The defendant doesn't have a license, has no registration, no proof of insurance. There's shell casing in the front seat cup holder. Defendant's acting nervy and sweaty. He's got some sort of like MOLE bag strapped to his chest with a knife clipped to it. Defendant or suspect says, no, I don't have any weapons. Well, I do have a shotgun in the trunk. So officers under the aegis of officer safety, get him out of the vehicle, leave the knife and bag. While they're chatting with him, K9 comes out and gives a sniff. During the safety frisk, the Terry frisk for safety purposes, plain feel meth pipe in the dude's pocket. He admits it's meth. He admits that he uses meth, and gets Mirandized. Defendant gets put in a police vehicle. So there we've got, arguments about custody and stuff. Dog, no surprise, alerts at meth head's car, and they search the vehicle. They find 2 firearms in the camo bag that he had strapped to him. Big jar of meth in the console, meth bag in the passenger side door, 2 shotguns in the trunk, and a bunch of ID documents that don't belong to the defendant. He therefore gets charged with stuff and challenges everything, as defendants do. Says there was no reasonable articulable suspicion, no PC, illegal search. Court does find that there's plenty of reason for the stop, observed traffic infractions. Suppresses the evidence anyway because the amount of time that he was sitting there waiting for the canine to sniff after he'd already been basically taken into custody on the paraphernalia was too long. So that comes back. We win that one as well. So Colorado Supreme Court says, no. Like, this isn't it's never been a static environment. You can develop PC as you go. You can develop reasonable articulable suspicion for other avenues of investigation during a stop, and you don't have to fully arrest someone for that to effectually be an arrest and allow. So that guy was in custody in the back of the car. They're like, the defendant does not need to be told that, just like the defense gets to say that they were in custody even though they weren't formally arrested. So can we. So that time that they were waiting for the dog sniff, completely irrelevant, because that dude was under arrest, effectively. He was in custody. He was not going home that day. Dog can come out and sniff after arrest, no problem. There's no time limit on that. So the sniff was good, the search was good, and any evidence seized as part of that was good.
You got his own gas fob.
Yeah, I'll fight it. Like I said.
Okay.
So yeah, we had they go through all the items that led to PC for the search there, including the empty shell casing, the nervousness, the shotgun, and the admission of the shotgun in the truck, and kind of being kitted out with weapon adjacent stuff. So there we go. People versus Seymour. This one's kind of a mess. I've read this case a bunch of times, and I'll do my best to explain it to you guys. But if you have questions, so do we. This is a case where it's a big media case. I'm sure you guys have heard of it. 3 kids burned down a house in Denver. 5 people are inside, and they all die. What's not covered in these slides or in the Supreme Court opinion is they actually got the wrong house. These weren't the people that they were targeting. It was they were after retribution for something, and this was an immigrant family from Somalia, I think, just in bed for the night. So doesn't make things any more horrific. 5 people dying, being burned alive, but there you go. The problem is, because there was that absolute, these people got the wrong place, so there was no identifiable motive. It was a mistake. So the investigation was just hit wall after wall after wall. The perpetrators were all masked. They were on surveillance, neighborhood surveillance, but they were all masked. Couldn't find them on traffic cams. No identifiable motives. All the typical investigation tools hit a wall. So the law enforcement decided, let's do a reverse keyword search, because these guys probably looked up the address of the place they burned down before they went there. So they asked Google to give them the names, addresses, and phone numbers of everybody who searched for that address for like 2 weeks. And Google said, pound sand, we that violates our privacy policy. We weren't going to do that. But we will give you anonymized IP addresses of people who have conducted that search. So after some back and forth and a few more denied warrants, that's what happens. Law enforcement asks for these anonymized IP addresses. They get them. They got like 16 addresses. They whittle it down to 5 IP addresses that seem to have investigatory merit for the investigation. They then go back to the court, get a warrant, just like Google told them to do, for the user ID, for user information on those IP addresses. They go, they get that. They find Seymour as one of the 5 people. He is one of the perpetrators. They arrest everybody, goes to trial. They're convicted. Now Seymour's saying that reverse keyword search is total crap, man. Like, I've got privacy interests that are violated all over the place. By and large, the Supreme Court agrees with that. Now, the good news is they upheld the search and upheld the conviction. He and his buddies are still in custody for the crimes that they committed. But I'm telling you, this is a weird order. It is a weird analysis they go through. Ultimately, what they come down to is nobody's done reverse keyword searches for this level of investigation ever before. This is an issue of first impression. There's no guidance from any of the federal courts. There's no guidance from any of their state courts. Colorado is right on the bleeding edge of this one, and they said, so because there was no prior interpretation, and because a neutral magistrate signed this warrant, the good faith exception applies, and the warrant stands. Now, what makes all of us now nervous is now there is a case out there saying a few things that are of huge import. One, everybody has a vested privacy interest in their Google search history, and that is a privacy interest that we as society are we believe is reasonable to keep your Google searches between you and Google. So boom, there you go. That's Fourth Amendment. You need a warrant to get to that stuff. Now, for a warrant to be valid, it needs to have PC, and it needs to be particularly described the place and items to be searched, right? The entirety of Google's banked up personal information database is huge, and that's the place to be searched. And so Seymour and his attorneys said, there's no way that is a particular place to be searched. You're basically saying, we're going to search the world for this information. And the Colorado Supreme Court says, no. Because you're asking Google for specific information, and law enforcement's not rifling through everything Google has. They're just getting a response from Google that is narrowly tailored and particular enough to stand. Then they said, basically, without actually saying it, but there was no PC for that second one. Going from the anonymized IP addresses that were like, okay, this is the relevant address, and it's being searched from people who are in Colorado, local to this. Those are the 2 bits of new information they added to the warrant and said we needed that. The court didn't explicitly say there's no PC there, but they pretty much said there's no PC there. And they also went on to say, we got a big question mark on this, that they're not saying that reverse keyword searches are approved or disapproved. They're saying we're not going to answer that question. Great. But in their analysis of what constitutes probable cause in this case, it is highly unlikely that a reverse keyword search warrant will be deemed good from here on out in the state of Colorado. So if you guys encounter something like that, it's time to get the whole big room of big brains together and see what we can come up with, because there needs to be something, according to the Supreme Court's dicta in this case, there needs to be something more than just, hey, this seems relevant. There has to be something saying this anonymized IP address we believe is linked to this person who committed this crime, which is going to be really impossible to do. I think there's probably some other ways to finagle this. but it would be very difficult and extremely case specific. So it's a good result in that verified bad people who did horrible, horrible things are still being held responsible. But when it comes to reverse keyword searches, and as they've been interpreted by our state Supreme Court, I would not want a case that relied on those. All right, TAR. So this goes to blood draws and express consent. We've got a bunch of laws saying that express consent or implied consent is good. We've got saying if you're unconscious, your implied consent can allow for a warrantless blood draw. TAR basically explicitly says a conscious driver may revoke consent, and if they revoke consent, you should get a warrant. That's how I've been doing things for a long time, I believe, so no real worries there, but that is officially the way that express consent will be interpreted in Colorado for till the next case. Okay. Garcia v. People. This is kind of a lawyer-specific case, but it does intersect with law enforcement. Garcia, yeah.
Set the question up. Oh, got it.
Sure.
Stats. Go ahead.
Cool. That's a great question. So the question is, with the TAR ruling allowing for the withdrawal of consent, will that mean that we cannot use refusals against folks moving forward in court? No, that is solid. We are still on really solid ground with using refusals against folks. The case at the top of the slide there, Birchfield, Supreme Court's case said absolutely that's still admissible. Basically, you can withdraw. The way that the way we're splitting this hair is you can withdraw consent after you've contacted law enforcement, but you have still consented up to that point. And the fact that you have changed your mind when you got in trouble is we can still use that at Department of Revenue hearings, in court, both motions and trial. So we're going to be still solid on that.
Relative to
Okay, so the question is there a requirement now to inform people that they have the right to refuse these tests? I don't see TAR going that far, but I don't hate that as a prophylactic moving forward in terms of that's a reasonable precaution to take against the next case on this theme, right? I don't think it's required. I don't think we'll see an adverse law that way, based on the very clear and well-established express consent language. But and the fact that we still see refusals all the time pretty much establishes that people know that they have that they can refuse to do that. And I think it's also implicit in the express consent advisement when you're talking about penalties for refusal. So I think we're solid. If people want to go the extra step and be like, because as I've talked about, the consequences of refusal, you know that you can refuse to take this test. And again, these are the consequences. It's up to you. Yeah. That's the best answer I got there, but that's where the law sits. Garcia killed somebody, got investigated, fled to Mexico. We tried to extradite him. Mexico did not extradite him. So law enforcement, either prosecutors or the Mesa County sheriff, whomever, sent all the information from their investigation down to Mexico. The prosecutors in Mexico brought a case against Garcia. He was acquitted. He comes back to the United States thinking he's beat the charge, gets arrested, gets tried, gets convicted, and says, hey, man, that's not fair at all. I already got acquitted. This is double jeopardy. It's kind of a legal nuance, but because he was prosecuted without really Mesa County's prosecutor's office or the law enforcement agency, the sheriff there, kind of pushing the prosecution and controlling the prosecution just through a different sovereign, it does not count. His conviction stands. You cannot get tried under basically different evidentiary standards and different rules and then come back to the states and say, ollie oxen free. Bowler. This is one where we included a ton of actual dialogue in the slide because it's pretty indicative of interactions law enforcement has with folks like this. Bowler stabbed his roommate and covered in blood, starts walking down the middle of the road in the middle of the night, but it's snowy and icy because it's March in Colorado. Officers not investigating the homicide contact him just on community safety concerns and notice that he's covered in blood, ask him what's up with that. He just keeps kind of veering away from topic, saying, it's Jesus' blood. And they ask him, hey, will you get out of the road? Will you take a seat? He does so. He's very cooperative, sits in a non-threatening manner, keeps talking about the blood not belonging to anybody except Jesus, asks the officer if he's the police officer in charge, keeps getting asking the officer to call the defendant, Bowler's grandfather. We don't know why. And saying stuff about, you don't know who I am unless you understand God. The officer tries to determine where he's bleeding from, where Bowler's bleeding from. He continues to veer off. And then they get the call that this guy's probably, based on, dispatch putting two and two together, this guy's probably involved in the stabbing homicide recently up the road. So they, after trying to make sure he wasn't bleeding to death and getting him off the road, they then arrest him, handcuff him, and take him into custody. They don't interview him further. And therefore they do not Mirandize him. Despite that, the court suppresses all the statements. A guy pleads NGRI, and prosecutor wants to use those statements to show he's trying to avoid answering the questions. He's avoiding reasonable questions about his own safety and what's going on in order to avoid saying anything inculpatory. So we want those statements. Defense doesn't want us to have those statements. Statements get suppressed. We appeal. And the question comes down to, was he in custody when he gave those statements? Your common Matheny analysis. If you guys had this training last year, you know that the Supreme Court is really into the tone of the interaction. No exception here. Because the officer was mostly concerned with getting Bowler out of the road and figuring out if he was bleeding and if he needed medical and things like that, and was using a conversational tone to keep somebody who was obviously in some level of distress calm and from escalating. Everything was good. All those statements came in. Supreme Court says suppression was reversed. Here's one for persons again. Johnson was driving along, sees a 10-year-old girl walking her dog, pulls over and asks some innocuous questions about the dog, then asks where she lives and how old she is, tells her she's old enough to have a boyfriend. She's 10. She gets super creeped out, walks away from him, tells people who tell the police. Police go out and investigate and charge him with attempted enticement. Court of Appeals says, no way, man, that's not, he didn't actually attempt that. He was just being creepy. Being creepy is not illegal. The Supreme Court says, no, he absolutely he was attempting to entice this girl. She just got creeped out and walked away. we shouldn't be teaching kids, hey, wait till the creep like gets you in the car before running away. Like, kid had good radar, and the Court of Appeals used the wrong standard when they were looking at attempt. They sort of focused on all the things that he didn't do that would constitute a substantial step, and the court and the Supreme Court says, no, he definitely was trying something funky here. He was definitely being a creep, and that conviction stands. So there we go. Any final questions? Way less than 3 hours. All right. Guys, have a good afternoon. Thank you very much. If you come up with any questions, please don't hesitate to reach out. We're happy to answer them. I'll be looking into the careless phone thing with a little more detail and getting some email back answers for you on that. That goes for anybody watching the recording. If you have any questions, please do reach out. We're happy to look at stuff and research things. That goes. You guys have the on-call phone, so if you get a question in the middle of the night, whether it relates to this presentation or not, please don't hesitate to call. We're happy to help you guys out. Cool.
Okay.